Good morning, everyone, and welcome to this Evershed Sutherland Propcast. Today we are covering the Renters' Right Act countdown to implementation. Quick introduction from me. I'm Balraj Birdi, a partner here at Evershed Sutherland in London. I specialise in the development, finance and investment of living and mixed-use real estate assets, with a particular focus on regulatory living matters, which underpin most living assets. I am joined today by my colleague Thom.
Hello and welcome everyone. Thank you for joining. My name is Thom and I'm a Principal Associate based in Evershed Sutherland's London office. I'm part of our living group and I specialise in living regulatory matters, which covers a broad range of subsectors such as build to rent, purpose-built student accommodation and senior living.
Thanks very much, Steve. So I'll just take us through some brief background to the Renters' Rights Act. Firstly, I think the main overarching point here is that this is probably the most significant reform to the residential letting market in a generation. Now, the government's aim is to improve tenants' security, allowing them to stay in their homes longer whilst attempting to strike a fair balance between security of tenure, rent negotiation, and industry investment scope. The Act will have a significant impact on owners and occupiers of residential property. I think the key thing to note is that it will affect every stage of renting residential property. Now that goes from advertising, letting, rent review, and regaining possession from a tenant. Now the Act extends to England only for the majority of its provision, with only a small number altering the existing rental regime in Scotland and Wales. Company-let tenancies and common law tenancies will fall outside the new regime under the Renters' Right Act. So, the Act received royal assent in October 2025. However, the majority of provisions still require secondary legislation to bring them into force. Now, the government has announced 3 phases for implementation. So, phase 1, which comes into effect as of 1st May 2026, will abolish the Section 21 no-fault termination right. It will introduce amended grounds for possession, as well as some new grounds. It will move to periodic assured tenancies in the private rented sector. Statutory rent review process will be the only way to review rent. There will be anti-discrimination provisions coming in, as well as a right to request permission for a pet for tenants. Later in 2026, we will see phase 2, which will bring in a private rented sector database and a landlord redress scheme, effectively like an ombudsman scheme. Phase 3, for which dates will be set following some government consultations, will apply the Decent Home Standard throughout the private rented sector, as well as bringing in the AWAB's law. So, conscious of the time we have available today, we will focus on the phase 1 implementation, which will bring in, we consider, perhaps the most significant changes, and we will look at these changes from a build-to-rent, private rented sector, and purpose-built student accommodation lens. So first up is the removal of assured short-hold tenancies, which Steve will take us through.
Thank you, Balraj. So, as I'm sure many of our listeners have heard, the Renters' Rights Act is going to abolish the assured short-hold tenancies we're all so familiar with and replace them with assured tenancies from 1st of May of this year. This marks a major overhaul of the residential lettings market in England and one that is going to impact all subsectors of the market. So is this just a rebrand, or does it actually matter? Well, assured short-hold tenancies and assured tenancies are 2 types of tenancy regulated under the Housing Act 1988. However, only assured short-hold tenancies come with the ability to serve a Section 21 so-called no-fault eviction notice on tenants. Perhaps unsurprisingly, most landlords opt for assured short-hold tenancies, so much so that many people will not have heard of assured tenancies before the Renters' Rights Act breathed new life into them. So the bottom line is that when assured short-hold tenancies are banned, so are Section 21 notices and a landlord's ability to obtain possession without being able to prove one or more statutory grounds for possession. However, the Renters' Rights Act goes further than a ban on assured short-hold tenancies. Fixed terms are also to be banned from 1st of May. So all assured tenancies will be periodic on a monthly rental period basis. This combination of reforms is perhaps the most talked about of all the Renters' Rights Act changes, and is really a key element to bring about the government's objective of providing tenants with increased security in their homes.
So, Steve, if I'm understanding this correctly, so we will effectively have rolling periodic tenancies with no end date. So, will we, in effect, have tenancies for life?
Correct. That is, unless the tenant serves notice to quit, or the landlord is able to rely on the statutory grounds for possession, such as tenant breach, rent arrears, or one of the new grounds, for instance, a landlord selling the property. We could take a look at the grounds for possession in more detail later in the session. So the first order of business for landlords is to update their form of tenancy agreement for all lettings from 1st of May. Template assured short-hold tenancy documents will need to be converted to periodic assured tenancies that comply with the Renters' Rights Act. It's worth noting that the regulations will actually implement these changes on 1st of May have not yet been issued. We expect that they'll arrive at some point over the next month. However, there's no guarantee. Some detail on the reforms is still to be filled in by these regulations, and that's particularly true in relation to purpose-built student accommodation. However, as we have a good idea of where the changes should land, a lot of the preparatory work can be carried out now. This is already in hand in many parts of the BTR market as landlords get ready for the changes. We are seeing a number of investors getting out in front of these changes and even switching to periodic assured tenancies now. Certainly, we've seen some tenants starting to question why they should agree to a fixed term now when they would be entitled to a periodic tenancy come 1st of May.
Okay, thanks, Steve. So we appreciate that we will effectively have new tenancies impacted here. What will happen to existing short-hold tenancies come 1st May?
Okay, so for assured short-hold tenancies that are already in place on 1st of May, of which no doubt there'll be many, the Act contains transitionary provisions that will automatically convert them to a periodic assured tenancy. And any provisions in the assured short-hold tenancy that conflict with the Act will no longer be enforceable.
Okay, so typically we do see short-hold tenancies will have some form of contractual break clauses, sometimes agreed between landlord and tenant at the outset of the fixed term tenancy. What will happen to those contractual break clauses come 1st of May?
Well, as I said, landlords will only be able to obtain possession if they can prove statutory grounds for possession. So landlords' contractual break clauses will have no effect. Tenants, on the other hand, will be entitled to serve 2 months' notice to quit at any point during the periodic tenancy.
Okay, so just taking that point, what you just mentioned last there, tenants are entitled to serve 2 months' notice to quit at any point during the periodic tenancy. I mean, could that then lead to very much sort of shorter term occupation? Because under the current regime, there's been a minimum, usually 6-month fixed period, shall we say, for tenants.
Well, yes, we expect that in a small number of cases, a tenant could use the new notice to quit provisions to end a tenancy after, say, only a few months. However, it appears likely in the vast majority of cases, tenants are really looking for a place to call home, so the effect of this may be relatively limited.
Okay, thanks, Steve.
So, Balraj, we've prepared the assured tenancy agreement. It's ready to be used and the property is about to be marketed. Is there anything else new that we need to consider under the Renters' Rights Act?
Well, I think it's very much so, Steve. There are some new pre-tenancy regulations that are coming in, and these effectively will impact landlords and agents who will be unable to encourage or accept a rental price higher than the advertised rental listing, and there are restrictions on accepting advance payments of rent. So the first development here is intended to end bidding wars, which means that landlords and agents will need to take an even greater care when finalizing listings. The penalties for breaching these obligations cannot be avoided by failing to specify a rental price, as there's a requirement to specify a specific proposed rent in the listing. So essentially, landlords will have to advertise a price and cannot then accept a higher price to that advertised. Equally, landlords will not be able to ask for or accept payments of rent in advance. So any payments taken in advance will be a prohibited pre-tenancy payment under the Tenant Fees Act 2019. And landlords and agents accepting such payments will, of course, expose themselves to financial penalties. There's a slight nuance here to note, and that is that once a tenancy agreement has been signed, a landlord can only ask for or accept a payment of up to 1 month's rent in advance. So any provisions in a tenancy agreement requiring sums over 1 month's rent would be unenforceable.
Okay, but aren't advance payments used when tenants might not meet affordability criteria or are perhaps based overseas? How's that going to be impacted?
That will be impacted. That's a fair observation there, Steve. But the government's intention and the redress that they're seeking is to effectively make a fairer market, whereby certain tenants who perhaps cannot make the advance payments are not losing out on effectively what could be their ideal home. So this is effectively part of the landlord's redress to strike that fair balance between landlord and tenant.
So we're trying to level the playing field.
Exactly. And finally, I think on this point, I think the change will affect new tenancies, and therefore tenancy agreements in place before the Act comes into force, i.e. the 1st of May, and which required a payment of rent in advance, would not need to be amended. So next up is rent review, which Steve will take us through.
Okay, so let's take a look at the new or newish rent review provisions of the Renters' Rights Act. This is another reform that sparked a lot of debate in Parliament and amongst stakeholders in the build-to-rent sector. Whilst the reforms are not the rent controls of the 1970s, they do put tenants in a stronger position to negotiate the level of rent increases with their landlords. So what are the changes? Well, in short, subject to a few exceptions, all contractual rent review provisions are to be banned from 1st of May, and any provisions in tenancies that provide for such rent review will not be enforceable. Instead, landlords who wish to review the rent will need to use an amended version of the current statutory rent review process set out in Section 13 of the Housing Act 1988. This rent review process is little used and perhaps little known in the market. Generally speaking, a new rent would be negotiated at the point of renewing a fixed term, or if the tenancy is a little bit longer than that, the tenancy might include contractual annual rent review provisions. So the statutory process was never really used. Just a quick note before we dive into the process on the exceptions I mentioned. There is a carve out for certain low cost housing tenancies of social or affordable housing. So for these tenancies, and again, the detail is to be set out in regulations, but these tenancies will not be subject to the ban on contractual rent review, so they'll be able to retain those sorts of provisions, and they'll also be able to use a similar statutory rent review process under a new Section 13 of the Act. Section 13A of the Act, should landlords wish to rely on that instead. So turning to the review process itself, it allows landlords to set a new rent annually by service of notice on their tenants. So if we take it step by step, first the landlord serves a notice under Section 13 on the tenant. This notice will specify the new rent. The notice must be in a prescribed form, which again is to be confirmed by regulations at this stage. The notice must be served at least 2 months before the rent increase is to take effect. The rent increase cannot take effect in the first year of the tenancy, so the earliest opportunity to serve the notice will be in the 10th month of the tenancy. If we're a little further on in the tenancy and the rent has previously been reviewed, we count from the date that the last review took effect to calculate when the next review can occur. So essentially, this provides for annual rent review. The new rent will then take effect on the date specified in the notice, which is the beginning of a new rental period that is at least 2 months after the service of the notice, unless before that date, either the tenant applies to the first tier tribunal for a determination of the open market rent payable, or the landlord and tenant agree to a new rent, which is lower than the rent proposed in the Section 13 notice. So if the tenant applies to the tribunal is going to be asked to make a determination of the market rent payable. However, it is important to note that if such a determination is higher than the rent the landlord proposed, the determined rent will be capped at the landlord's proposed rent. Also, the date that the new rent will take effect cannot be earlier than the date of the tribunal's determination. It will not be backdated to when the rent review should have taken effect under the rent review notice.
Okay, Steve. So to be clear, in short, the landlord will propose a new rent when it is entitled to review the rent. If the tenant doesn't agree to the proposed new rent, is the onus then on the tenant to apply to the tribunal for determination?
Yes, that's right. So if the tenant does not apply to the tribunal to challenge the new rent, it will take effect on the date specified in the rent review notice.
Okay, so if in this scenario, tenant does make that application to the tribunal, as we know has been hotly debated in Parliament and throughout the industry, generally the tribunal and court systems are delayed due to the effectively overloading of claims to deal with. Could a rent review application be significantly delayed? And if so, what's the implementation and perhaps the intention for the government here?
Well, the government has said that if there are extensive delays, the position could be reviewed. But part of the delay involved in a tribunal application seems to be a bit of a feature rather than a bug. So landlords are clearly incentivized to engage with tenants and negotiate and agree rents rather than face the delays delays to a rent increase that a tribunal application may bring. The Renters' Rights Act gives tenants a stronger negotiating position than they've historically enjoyed, which is something the government was keen to address in the name of fairness.
So I think, Steve, it seems that whilst this obviously is clearly not a rent control or a return to the 1970s of rent acts, there is certainly some encouragement, shall we say, here for landlords and tenants to effectively get together and try to agree a rent, as opposed to then awaiting for a tribunal determination, at which point the rent review will effectively come into effect when the determination is made. And during that period, the rent would stay at its current level.
That's right.
Yeah. Okay. Thanks very much, Steve, for that. We will now look at again one of perhaps the major changes and perhaps one of the main headlines throughout the media since I think the renters reform bill, shall we say, as it once was, and now the act was announced, and this is the end of no fault eviction, coupled with some updated grounds for possession. So key feature, as we say, is the end of the Section 21 no fault evictions. And what this will apply to is both new and existing tenancies as of the 1st of May. So this will implement an immediate ban on Section 21 notices. Now, there are some transitional provisions which will allow for landlords to rely on a Section 21 notice which is served before the 1st of May. The position will naturally then vary whether or not possession proceedings have already been commenced in reliance on a valid Section 21 notice. Now, whilst no fault eviction will effectively be removed, we do have the grounds for possession, both existing and some new and updated grounds, which is often known as the Section 8 procedure. Now, the first, shall we say, ground to highlight, which is the new ground, is where a landlord wishes to sell the property or grant a long lease, i.e. a 21-year or more lease of a property. Now, that's a mandatory ground There are various hoops for landlords to jump through in order to avail themselves of that ground, effectively going to there being a genuine sale. There's a longer notice period, i.e. it's a 4-month notice period. And once a landlord does obtain possession using the sale of this new sale ground, a landlord cannot then re-let the property for 1 year. And that's, of course, to discourage any malpractice of this ground. For our lender community out there, the sale by mortgagee ground has been varied in that it will no longer be necessary for the mortgage over a property to have been granted before the start of the tenancy. So that's certainly good news for lenders looking to repossess in order to realise their security in breach of a loan default. The rent arrears ground, which again is another mandatory ground, the length of time for arrears has been extended so that there must be 13 weeks or 3 months of arrears must be unpaid at the date of the Section 8 notice being served by the landlord, and also at the court hearing date. And the notice period has been extended from 2 weeks to 4 weeks. Now, and as ever, these grounds are linked, not all, but some are linked to landlord compliance matters. And as we've known under the current regime, whereby tenancy deposit protection, compliance with gas safety, etc., are all coupled with a landlord being able to avail themselves of grounds for possession. Now, there is also the ground 6, which we'd like to highlight, which is where a landlord intends to demolish or reconstruct the property, and such works cannot be done with a tenant in occupation. Now, the only change coming through is the notice period is being extended from 2 months to 4 months here.
So what if we just want to refurbish rather than full redevelopment of the property?
Well, that's a very interesting point you make there, Steve. And the question here is, well, what is the intended consequence? Because under the current regime, I think investors would look to use the Section 21, wait till the end of a tenancy to serve their no-fault eviction notice, regain possession, spend capital expenditure in refurbishing a property, typically new kitchen, bathrooms, flooring, etc., possibly going further in some cases, of course, and then reletting. Under the new regime, as is currently expected to come in, there is only this ground 6, which looks at demolish or reconstructing the property. And currently we don't have any further guidance as to whether there are certain bars, as we see in some other jurisdictions like Scotland, where there are bars over whether you are lifting floors or doing works to a certain level, which enable you to regain possession. So at this stage, we can only say perhaps it's something that will effectively sort of be flushed out as the new regime comes in and the market adjusts and reacts. But this is certainly, I think, an interesting point for the investor and tenant community, because it naturally impacts the quality of residential property on the letting market.
Okay, understood.
So now I think we move on to purpose-built student accommodation. Over to you, Steve.
Great, thanks, Balraj. So there are a number of special rules for purpose-built student accommodation. The government accepted that there are different considerations for this subsector of the market, and in particular that abolishing fixed terms would not be appropriate in all cases. So there'll still be the exemptions for academic institutions, letting out halls of residence that we're already familiar with, that operate similar to the current exemptions from assured short-hold tenancies. However, going forward, purpose-built student accommodation let by private landlords is expected to be exempt where the landlord is a member of the Unipol or ANUK student housing codes of practice. The detail and extent of this wider exemption for private landlords is to be set out in regulations that have yet to be issued, but we're hoping for some clarity on those points shortly. Where a private landlord of purpose-built student accommodation exemption applies, newly granted tenancies will not be assured tenancies. They will be common law tenancies. So these are tenancies that are not regulated by the Housing Act 1988 and are therefore not subject to the majority of the Renters' Rights Act reforms. Fixed terms will be permissible, as will landlords' notices to quit. In addition to this, PBSA lettings that qualify for the exemption are likely to also be exempt from HMO regulations in the Housing Act 2004. Currently, PBSA landlords of HMO properties are required to apply for HMO licenses from the local authority. If the regulations are as expected, this further exemption will be a welcome reduction in regulation for purpose-built student accommodation private landlords. However, this doesn't mean that they will be entirely unregulated. We understand that the Unipol and ANUK codes are in the process of being amended as part of the Renters' Rights Act reforms, and we think it's likely that these codes will require a greater degree of landlord compliance. So, for instance, requirements that deposits are protected under tenancy deposit schemes. Furthermore, the Tenant Fees Act will apply to PBSA lettings. This means no advance payments of rent before the tenancy is entered into, which could impact lettings to overseas students that typically provide for advance rent in lieu of references or guarantors. The PBSA exemption only goes so far. It will not cover all private student lets. In particular, it will not cover lettings of properties that are not purpose-built student accommodation. So landlords who own non-purpose-built student accommodation that is let to students will be subject to the Renters' Rights Act regime and will need to grant assured tenancies. There is a new ground 4A for possession that's aimed at non-PBSA student lets, but this ground has met with some criticism from stakeholders in the subsector. Firstly, it will only apply to houses in multiple occupation. So if you're a private landlord letting non-PBSA to a single student, say, you cannot use this ground. The letting is effectively no different to build to rent. Secondly, the ground requires advance notice to the tenant prior to entering into the tenancy that the ground will be used, and it is subject to a number of restrictions and requirements as to when and how it can be exercised. This is intended to fit in with the academic year, but critics have pointed out that the provisions appear to be quite cumbersome. That said, we anticipate that issues are unlikely to arise in the vast majority of cases, as students tend to naturally move on at the end of academic years.
So, Steve, I think you mentioned there that the PBSA exemption will only apply to new lettings. So what happens to the current PBSA lettings that would have been exempted?
So they will be assured tenancies, and they will not qualify for the exemption. However, in these circumstances, there is a transitional provision that allows these PBSA landlords to use a modified version of Ground 4A, which isn't restricted to HMOs, and there's no requirement to give advance notice that the ground will be used before having entered into the tenancy. However, do note that once the provisions come into force on 1st of May, such landlords will have a 1-month time limit to serve this advance notice on their tenants. So PBSA landlords need to be ready to serve their notices promptly. And this ground will then allow them to regain possession at the end of the academic year, as they would expect under the fixed term.
Yeah, so certainly it seems like some work to do there in preparation, given effectively the transition for existing PBSA lettings and equally getting prepared for new.
Yes, that's right.
Yeah. Okay, great. Well, thanks very much, Steve. We are going to briefly look at the additional compliance that is coming in for landlords. Now, the Act is introducing a new private rented sector landlord ombudsman service and also a new private rented sector database. There is still some detail awaited as to these new systems or what they will look at, but essentially what they are there to provide is a redress scheme for tenants, effectively looking at to see are there any bad reviews effectively. Is a landlord registered to be a landlord under these schemes? And naturally, we expect that these are probably linked to a landlord being able to use some of the grounds for possession. Landlords will be obliged to register themselves here and their properties, and naturally, any breaches of compliance will come with penalty. I think there has been talk of significant financial penalties, up to 40,000 for persistent breaches. So it certainly seems like there is effectively more bite coming in for landlords to ensure that they comply with these aspects, both from ability to let and regain possession. So coming on to our closing comments, Steve, just some final thoughts and remarks.
Well, as we've discussed, I think the devil's in the detail, and we're expecting regulations to arrive over the next few weeks, which is going to hopefully provide further clarity on the expected changes and how they will be implemented. We know that we know the when, but not the how at this stage. So we'll be keeping a close eye on that, and equally, landlords need to be well informed of their obligations, because this is a move to greater regulation, backed up with penalties for those that don't comply. So I think everybody involved in the sector needs to keep one eye open for new regulations when they land, because they're going to have to take action and adapt to these changes.
Right, thanks very much, Steve. And I think in addition, I think I would add that overall the key changes are bringing enhanced regulations for landlords and their agents, and perhaps the increased security of tenure for tenants will work well for both the tenant community and investors into the BTR, PRS and PBSA industries in view of less void periods. However, equally, the changes to a landlord's right to review rent seem to encourage rent negotiation, leading to quicker settlement. At least that appears to be the government's intention here. So I think we expect some time for the market to adjust to the changes, and inevitably where there is change, there could be some other letting models considered for different housing types. So I think in short, it's interesting times ahead for the sector, and the investor community still have time to get ready, though the 1st of May isn't that far away. Well, that's all from us today. Thank you all to joining us today and for listening.
Yes, thank you very much.